Good afternoon, everyone, and welcome to the Property Appraisers Continuing Education series. And today we will discuss understanding Florida's exemptions, not only the homestead exemption, but all exemptions that are available to all our taxpayers if they qualify. My name is Kevin McKeon. I'm the Deputy of Assessment Administration. Joining me will be Amy Lesk, our exemption specialist. And we welcome you. We thank you for joining us. And if you have any questions during the presentation, we'll more than happy to stop during the presentation. Please type them into the chat box, and we will answer all your questions as they come up, or we can wait till the end as well, your choice. So I'm going to turn it over to Amy to discuss all the personal exemptions that are available to our taxpayers here in Pinellas County in Florida.
Good afternoon, everybody. Can you hear me okay? Okay. So we have a lot of different personal exemptions here in Florida, so I'm going to go over some of them with you guys. So there is, in 2023, a new law passed changing from the widower, disability, the blind. It used to be $500 off your assessed value. It went up to $5,000. If you already had that on your property, we automatically made that change. That saves you, it was about $10 a year. Now it went up to about $100 savings on your taxes a year. Homestead is not required for any of these exemptions, but you must be a Florida resident to get one of them. We have exemptions for totally and permanently disabled persons that meet requirements of paraplegic, hemiplegic, totally and permanently disabled that must use a wheelchair for mobility, or legally blind. They must meet the 2023 total gross household income limit of $35,693 or less. Provide that income backup, which would be like your 1099s. And then 2 Florida licensed physicians would fill out supporting documents as well. And then this one does renew yearly, so you would ask for your income every year for that, and we would send you out information, and then you would provide your yearly income to us. We have a low income senior exemption. It's available to those who have homestead that are at least 65 years old. As of January 1, 2024, this exemption is also income-based. If the 2023 adjusted gross household income is $36,614 or less, you would qualify for this, and it would reduce your taxes on your taxing district. Here's a quick list of the cities that participate in it. It shows the approximate savings for each taxing district. For example, if you are in the city of Dunedin, you would get an additional $50,000 off your city millage, and that would give you about a $207 annual deduction off your taxes. There is a low-income senior long-term residency exemption. There are 3 municipalities in our county that participate in this exemption: St. Petersburg, North Reddington Beach, and Safety Harbor. If you qualify for the low-income senior and you've been receiving the homestead on that current home for 25 years or more, and your just value of that property is $250,000 or less, and the year of that initial application, you are exempt from your municipality taxes. For the state of Florida and for all the exemptions, dates are very important to us. You must own, occupy, and be a permanent resident as of January 1st and make application by March 1st. The VA disabilities have an effective date of January 1st, 2024 or prior to be eligible for that current year. And for the senior exemption, you must be 65 as of January 1st, 2024 or prior, and submit your supporting income by June 1st of 2024. We also have exemptions for disabled veterans and first responders. We have the veteran service connected 10% or greater. You're entitled to 5,000 off the assessed value, which is approximately $100 savings a year. There's a total and permanent service connected disability exemption that would entitle you to be tax exempt off of the ad valorem taxes. There's ones for veterans that are 65 or older with a combat disability, and that would reduce the taxable value of your VA percentage off of the taxable value of your property there. We have veterans who are confined to a wheelchair requiring special adapted housing, makes you exempt from the ad valorem taxes. And then first responders that are total and permanent that occurred in the line of duty are exempt also from the ad valorem taxes. For the veteran exemptions, there's a few examples of documents that we would require to be able to process those. There's a summary of benefits letter that the veterans get every December. We could use that. It would show your percentage on there of your VA disability. We could use that for proof. The rating decision letter or award letter with the effective date of the disability, that would be like for the combat one, that would show your disability to prove that. The DD 214 shows that you were honorably discharged. For surviving spouses, it would also be the death certificate of a veteran. All of these do pass on to a surviving spouse as well. And there is a county office, Pinellas County Veteran Services, that help you, a veteran and their family, apply for any of the veteran discounts, and they would help you obtaining any of that proof if you need it. And they also do help us with the combat and some of the other letters they can give us backup for that too. Deployed service members must be receiving the homestead exemption to get the discount. They have to be deployed to a designated operation that is designated by the Florida legislature. This exemption will reduce your taxes by the number of days deployed outside the U.S. This exemption is available to active duty military or reserves. For total and permanent disabled veterans and their surviving spouses, you can apply to receive a prorated refund on the taxes on the new homestead when you're moving from a previous total and permanent homestead in the same year. And that would reduce your taxes for the part of the year that you owned it if you had total and permanent on a prior property and then on a new one. Effective for 2020 for purchases, for 2025, they will not have to have that total and permanent exemption on a prior property. This year they still do, but next year that rule is going away to get that refund then. I'm going to hand you back to Kevin.
Thank you, Amy. Any questions so far? There is one question. Go ahead, ma'am. We have one internal. I'll try to repeat it for everyone. It is. This whole presentation will be available online as well as all the others we've done previously. Yes, absolutely. And with the low income senior, it's most Social Security for most people is not taxable. It's adjusted gross income on your tax return if you file a tax return. So if to the extent that Social Security is not taxable, that would not be part of your adjusted gross income. Well, it depends how much money you make outside of Social Security. So if you have a large pension, if you have a 401k that you're getting distributions from, there will be a portion of your Social Security that is taxable. But if Social Security is your only source of income, more than likely it's not taxable. Anything else, Kyle? Okay, so we'll move on to This is a quick overview of a lot of material that we cover in many of our presentations. However, it's good to have a reminder for everyone because I mean, it tends to be a very complicated state when it comes to homestead exemptions. People who come from other states have a hard time understanding them, understanding the requirements. So we do our best on our website and through these presentations to educate the residents of Pinellas County. So a little bit of the history of the homestead exemption. The first homestead exemption started in 1934, which was $5,000. I don't know what real estate prices were way back then, some 80, almost 90 years ago, but chances are that exempted a lot of your property taxes, a $5,000 exemption. It doubled in the 1960s to 10, and in 1980, it became $25,000 homestead exemption. The big piece that is very relevant to longtime Florida homesteaders is in 92 to 95, the Save Our Homes Amendment came through, which basically capped, if you had homestead, your assessed value for tax purposes at a maximum of 3% the year after you qualified for homestead and every year thereafter. And we'll get into that and the effects of that on not only you as a longtime homesteader, but a new purchaser of your home when they become the owner. And then in 2008, the second homestead exemption of 25,000 came in, along with portability, which we will get into in this presentation as well. So the two homestead exemptions, the first 25,000 is off of the value of your home from 0 to 25, and it applies to all millage rates. The second 25,000 of value, and we're talking assessed value, is not subject to an exemption. And the third 25 from 50 to 75 is subject to exemption from all millage rates except schools. When the legislature instituted the second exemption in 2008, they didn't want to affect the amount of taxes collected for schools. So that second 25,000 is not an exemption for school taxes. And in a lot of cases, most of your school taxes are about a third of your total taxes here in Pinellas County. It's a little under 6 mils. If it's so, or 0.6%. So if you're looking at a 2% tax percentage on your taxes, 0.6 is a good portion of it. And then anything above 75 is not exempt from property taxes. All in all, the first and second 25,000, depending on where you live within the county, is initially worth about $500 to $1,000 a year and every year thereafter off of your taxes. But once you qualify, as I said, your Save Our Homes cap that was instituted back in the early 90s, you are capped for purposes of increases in your assessed value that will greatly reduce your taxes if you're a longtime homesteader. And I have a good example here in the presentation. Again, January 1 is very important in our world. Okay, you have to own and occupy as of a January 1 in order to qualify for homestead. So if you just recently purchased your home in January of 2024, the first year you will qualify for the homestead exemption is 1/1 of 25. Taxes are based on a calendar year. So your taxes are for January 1 to December 31. If you purchased a home with homestead on it, you inherit the homestead of the person you bought it from if they left it on the property through December 31. It doesn't automatically continue. You have to apply for homestead. One of the big things that people think is that it's automatic. It's not. As a matter of fact, almost 40% of all homes in Pinellas County are not homesteaded. They're vacation homes, they're investment homes, et cetera, et cetera. So until you apply for homestead, we really don't know anything about you. Even if you had a prior homestead in Pinellas County, let's say John and Mary Smith bought a homestead, had a homestead, they sold a home, they bought a new one. John and Mary Smith could be anybody in our world. So until they apply, we don't know who you are because we collect date of birth, social, driver's license, auto tag, etc. And the other important thing to understand is if you plan on getting married in the near future, the next January 1 after you're married, you can only have one homestead. So if you had two going into your marriage and you're keeping the other home, one of them has to be removed. And that is your choice as to which one you remove it from. But it's important that you do remove it and report to us that you are married, because it can result in a homestead violation and penalties and interest if you do not. Corporate entities, LLC cannot be homesteaded. It is not a person. It is a corporate entity, so they do not qualify for homestead. And again, permanent Florida resident means, for the most part, you have a driver's license in the state of Florida and your auto is registered in the state of Florida. Yes, ma'am. I have a question from the floor. Okay, sure. Yes. Yes. No, it's not a loophole. I will try. First, the question is, can a trust, if your property is in a trust, qualify for homestead? Absolutely, it can. However, the trustee of the trust must be the person who is living there and filing for homestead. Okay. So I mean, I personally have my house in a trust as well, but my wife and I are trustees, and it gives us the right to reside in that property and ownership in the real property, meaning land in that which is physically attached. A lot of trusts are created that give somebody ownership in personal property. That does not fly for purposes of homestead. It has to be an interest in real property. The other question is, can mom and dad and child be an owner of two homes and still qualify, or more, and still qualify for homestead? Absolutely. If you have the means and the wherewithal and you have 5 children and you decide to buy them all houses, but you don't want to give them all ownership of them, you can buy the home, and on the deed, it's you and your child as joint tenants with rights of survivorship, meaning you each own 100%. So child can apply on that home. Parent can still be a homesteader on the home that they own. That is not two homesteads, okay, in effect, because each one is 100% owner. Okay, does that help? Great. Recently, those of you who are homesteaded or have exemptions, you received this notice in the mail. This is not required by Florida law, but we have continued to do this practice in Pinellas County because it gives you an opportunity to let us know if, number one, if we have all your exemptions that you had in the prior year, and number two, to let us know if anything's changed. Okay, if there's a death of one of the owners, if you got married, you have an opportunity to tell us. If you turn 65 and may qualify for the senior exemption, this enables you to communicate with us to hopefully qualify for more exemptions if you're eligible, or remove some exemptions if in fact things change. That say you decided to rent your home because you're moving to another state, let us know. We don't want you to violate the homestead law. And up top, it has your homeowner's name and the exemptions that are currently on your property. This particular one is homestead, widow, veteran, surviving spouse. Important, if nothing's changed, no need to contact us. We're happy to take your call if you do, but there's no response required. This is just a reminder of the exemptions that you have on your property. The next mailing that you will receive from us is probably the most important mailing that you'll ever get from our office. This is mailed in late August. This is a notice of proposed property taxes. What this does is give you an initial indication, or the first indication, although it's published on our website earlier, of the value we have placed on your property, number one. And an indication of the exemptions you have on your property. So this top section here, it has last year's and this year's. So it's very important to pay attention to this. If you have homestead and you had it in 22 and into 23, your assessed value should have only gone up by 3%. If it went up by more than 3%, something else happened. You had an addition on your home, you added a pool or whatever, because any addition or any improvement to your home that adds to square footage, or something like a pool or a new patio, would go on over the cap and then be subject to the cap the next year. And we get all that information from each one of our taxing authorities in the form of permits. So each one of the cities reports all the permits that are filed for and approved in each one of their municipalities, because that increases their tax base as well. So they're very diligent about getting that to us. Your trim notice can always be viewed. Last year's trim is on our website. You can review that. And sometime in mid to late July, maybe early August, we will have 2024 values on our website. So we're required to have values to the Department of Revenue by June 1st. We're required to have preliminary values to all of our municipalities by May 1st. So if you're a brand new homesteader, let's say you bought in 23, you're going to be revalued to market 1/1/24. Okay. The best time to call us is in the May-June timeframe, because in most cases we have already finalized the value for your home for 1/1/24 by May 1st. You can start talking to the appraiser that is responsible for your area within Pinellas County, and you can start a dialogue as to if you think your value is too high. Nobody's going to complain if they think their value is too low. So save our homes. This is the most valuable, let's call it, quasi-exemption that you could have in the state of Florida. Again, the Lee County Property Appraiser in 1992 proposed a constitutional amendment. Why did he do that? What was happening was people were being priced out of their homes in Florida. That was a very rapid increase in values, and the values kept rising and rising and rising, and taxes kept rising. And so he proposed that once you qualify for homestead, the year after, your assessed value, there are three values on your home that you will see back on that trim notice. There is, and I'll go back to it if you don't mind. Right there, you've got market value. That is the value we are required by law to value every parcel of real estate in Pinellas County every January 1. Market value is determined by a variety of factors, but when it comes to a residential real estate, the primary driver of that value are sales. Sales of similar homes from the previous year. So 1/1/24, we'll be looking at 23 sales, okay, to determine the value. Assessed value, that is the value that you're locked in if you already have homestead. That amount can't be more than 3% of the year before because CPI was 3%, okay, in 2023. Okay, so you see last year was 70,156 and it went to 71,629. And the market value jumped $26,000. You only went up, whatever, $2,500 on the assessed value. That's the Save Our Homes cap. You're not paying any taxes on the difference between market and assessed. And then from assessed, we take all your exemptions off of that, okay, to determine your taxable value. And that's the value times the millage rate that all the municipalities and taxing authorities approve every year that determines the taxes you pay. Okay. So here's CPI. We all know in the last 3 years, consumer price index has been very high. Inflation has been high, 22, 23, 24. Caps it at 3%, even though 22 was 7%. 23 was 6.5%. Your assessed value can only go up by a maximum of 3%. Look at all the years before that. The 9 years before that, there wasn't 1 year where CPI was 3% or greater. Therefore, you only apply CPI because it's the lesser of the two. So you bought a home in 2013 and you qualified for homestead in 14, your assessed value barely increased between 14 and 21, because you're looking at 2.1%, less than 1%, et cetera, et cetera. And we all know what market values have done in Pinellas County. They've skyrocketed. So there's created that big gap between market value and assessed value, which is your Save Our Homes cap. If you're not a homesteaded property, residential real estate, that's let's say it's a vacation home or a commercial real estate, they're capped at 10%. That 10% cap came in 2008. So to the extent that market value exceeds 10, you're only going up by 10, except, and here it comes again, school taxes. You pay school taxes on the full market value on a non-homesteaded property. And all caps reset January 1, the year after transfer of the property. You bought a home in late 23, we're going to value it brand new, market equals assessed. If you're a brand new homesteader in Florida who just moved from another state, that first January 1 after you bought, market value equals assessed. So here's how, this is a quick example of how Save Our Homes cap works. We show market value going up by 5 and assessed value going up by the maximum of 3. You start creating this differential that you're not paying taxes on if you're a homesteaded property. So by year 7, you're looking at about a $44,000 Save Our Homes benefit. That again, there is no taxes applied to that differential. But let's say you sell the property. So there's your taxes, right? You can see the benefit of that Save Our Homes cap. The first year after purchase, you were paying $5,000. Over a 6-year time span, a 7-year time span, it only went up $1,100 on a compounded basis. That's not a lot. Now, we don't determine the tax rate. We determine the value and administer your assessed value if you're homesteaded. The rate applied to taxable value is determined by your municipalities and your taxing authorities. So somebody bought the home year 7, the next year, guess what? Their taxes went from $6,000 to $9,000. And a lot of people are shocked by that. But that is resetting the cap. New owner, cap resets. They now start their own cap going forward if they file for homestead. This is a great example. 2 houses in a very popular neighborhood in St. Petersburg, right next to one another. Same lot size, same square footage. The house on the left was bought in 2020, cap reset. they're paying roughly in 2023, they paid $4,700 in property taxes. The lady on the right bought in 1993, homesteaded right away. And as you know, the market goes in cycles. So 93 to 2005, going like this, she's capped, and then it came back down. Okay, dramatically by 2012, I think, or 2011 or 2012 was the bottom of the market before it started rising again. She's only paying $777 in taxes. Is that fair? Well, it's not for me to determine fair. That's the beauty of the Save Our Homes cap. And I did a quick calculation of let's say that home sold, okay, in 2024 for about $450,000. That's about what that home is worth today. Okay. The person in 2025, brand new homesteader, their taxes will be over $6,000. More than the person who bought in 2020, because that person has the benefit of the cap, right? And they didn't pay $450,000. So now the person on the left is going, huh, my taxes are less than yours. But a lot of times people don't know that when they buy a home, and they're shocked by it. And imagine if you thought your taxes were going to be $800 and your tax bill the next year was $5,800. Big difference. We touched a little bit about the 10% cap. Again, that's non-homesteaded property and commercial real estate. And the cap remains just like a homestead cap, as long as ownership doesn't change. But here's the kicker. A lot of people before the pandemic had vacation homes here in Florida. They decided to sell their home in California, Illinois, New York, and move to Florida permanently to their vacation home. The year they filed for homestead, cap reset. Even though values were going like this, they had a gap between their assessed value and market value because of the 10% cap. The first year, again, an unfortunate part of the law, the first year you file for homestead, even though you've owned it, market equals assessed. So a lot of people, they were better off leaving the 10% cap on because their taxes would have been less. I mean, we're talking waterfront property on the beach. The property values went up 60, 70, 80% in a 3-year span. Okay. They decided, I don't need the homestead exemption because I'm paying less taxes as long as I keep the 10% cap. And in the future, if market gets closer to assessed, because market's going maybe the other way or flattens, that's the time to file for homestead because you won't have that big gap that you lose, that 10% cap. And any new construction goes on over the cap. Now, we don't consider a new roof as new construction. We consider that as maintenance. You're maintaining your property. So we don't add maintenance items over the cap. But if you add square footage, you add a pool, you add a patio, whatever, that's going to go over the cap the next January 1 after it's finished. So this goes into a little bit of the recapture rule. Never can market or just value be greater, never can assessed value be greater than market value. If you look at that year 1, 2, 3, market's peaking, assessed is moving along at that CPI, and then market crashed back down. Think about that as 2007 to 2012, where market met assessed. They ride down together. Okay. But then now we're looking at 14 till now. We're looking at it over a 10% compounded annual growth rate between 2014 and 2023, which was crazy. Real estate, not supposed to do that, right? Well, it did it here in Florida. So that created that big gap between market and assessed. Questions? Anything out there, Kyle? Okay. So another really good law that came in 2008 was portability. Because again, you had property values from, that was 2007-8 was the peak of the last crazy rise in real estate values, right? Between 2001 and 2008. You had an incredible rise in market value. All the Floridians were protected because their assessed value was only going up by CPI, but they're like, we sell our home, we got to buy something comparable at a higher price because now the market's going crazy and our taxes are going to skyrocket because it goes to market value. Well, the legislature put in this concept of portability, meaning that difference between market and assessed on your current home, you can take with you to another Florida home. Now, this is a Florida home that's homesteaded. You can't do that from Georgia to Florida. This is all in anywhere in the state. Okay, you can take that difference with you to the new home and reduce where market won't equal assessed in that first year of purchase because you're moving some of that difference from your old homestead to your new homestead. Market equals assessed, but for portability from your prior homestead. And I'll show you an example. Now, there's a time limit to do this. You can't have homestead in 2019 and the next year you have it in 24 and say, oh, I want to take my differential on my part. No, you have it. There's a 3 January 1 requirement that used to be only 2. Okay. You have a question, ma'am? Uh-huh. Okay. What would do you know the gap of the time that you bought and sold? Hmm? Oh, it was your mom's
But
homestead.
I became the owner. Squeaking it to me, so I was still.
Right, but that's the one thing about ownership. You can be inherit, you can inherit a property. You can't inherit a homestead. No, that homestead was your mother's. You had never owned it.
Well, I owned it after.
Correct.
Which was like 5 years before.
Right, but in order to qualify for homestead, you have to own and occupy. Okay, so if a lot of people think they can inherit their parents' homestead, they can't. Oh, even if they're on the deed, as joint tenants with rights of survivorship, right? Okay, because the homesteader was the parents. It wasn't you. You never filed for homestead on that property. It went to market. Sure,
0 to 100.
sure,
1,500.
sure,
And a cut.
sure.
Just
Right,
like that.
right.
And that's what
right.
I had to do.
Yeah, it went to market value, unfortunately. Sure, absolutely. Uh-huh. Mhm.
In that example. So had the homestead, she was living there, right?
Only if she applied.
I had to-
If in fact that trust said you are the remainder. If mom passes, you get my house for purposes of estate planning, right? The remainder can't file for homestead because they're not an owner until mom passes, until mom passes. They don't own. They have a right to it. They have a right to inherit that real estate, but a remainder does not own the property. Yep. Yep. Okay, you are on all their deeds, right? As joint tenants with rights of survivorship. You have homestead on your own home as parents. The 5 kids have filed for homestead on the other 5 homes. Parents on the homes, mom and dad can be on the deed. Right. Right. Okay. Yes, ma'am, you could have. It would have reset the cap. It would have reset the cap, but then mom can apply for portability to her own house if mom's still alive. Yes, I mean, unfortunately, even good estate tax attorneys don't understand the law. But I mean, but at the same time, the kid could already, the child could already have a homestead already, right? And they can't have 2. So they would have to give up their homestead on their home, okay, in order to file for homestead on mom and dad's. So it's all timing. Okay. Man,
This is called education after the fact. Because when my mother became sickly, I did go to an attorney. And I legally did everything I had to do to make sure, to ensure I would have property. No one told me this far.
right.
I think that's, that's the value.
It is, and I mean, and I'll tell you a horror story. When I first came to the property appraiser's office about 7 years ago, again, hot neighborhood in St. Petersburg. They were paying $600 a year in taxes. A brother and a sister who lived there for 20 years. Only the brother, joint tenants with rights of survivorship. Only the brother had ever filed for homestead. He died. Property went to market value because she never filed for homestead. We have to follow the law. And we found out about his death 2 years later. So she owed 2 years worth of taxes and could no longer afford to live in the home. It's unfortunate that, we do our best to educate. And that's why we have these sessions, and that's why we post it all over our website, to let people know there is a way you can plan for this, but sometimes the timing just doesn't work out, and right.
I think that Pinellas, or your office is unique in that you're not trying to gouge people, you're educating them, you're saying this is how you're supposed to do it. So it's really important that message come across. I just want to clarify, in the brother-sister example, both brother and sister could apply for homestead in the same home.
Absolutely. They both lived there and they were both on the deed. Now, if brother was only on the deed, she couldn't have applied for homestead because you have to own and occupy. But they were both on the deed. And she sweetest lady I've ever met in my life. She goes, just tell me what I have to pay. I'm going to have to sell my house, because I can no longer afford to live there. It was horrible, but that's the nuance of the law. Now, there have been attempts at the legislature changing the law to allow for an inheritance of mom and dad's homestead. That unsuccessful so far. If you as a citizen think that's something that would be beneficial, contact your state, your state representative, your state senator. They're the ones who created the laws. But right. Right.
But when I went to that attorney, and he said to me, you need to go to a real estate attorney so you can get more information, or you can go to the property tax assessor so that you can understand your rights and that. Never.
Now, our office cannot give legal advice, okay, by law, but we do have lawyers on staff. We have 2 lawyers in our office. If you have a deed that you want to file to see if that's going to, and we'll get into this a little bit, to see if that's going to either hurt your homestead or help and what I can do, they're happy to talk to you about it before you file it. So you're not making a mistake that could cost you a lot in property taxes.
That's so. It's just citizen, looks good, we want to work with.
No, it's very simple. We feel that everyone should pay the proper amount of taxes that they're supposed to pay. Everyone should get the proper exemption that they qualify for. I mean, that's why the laws are there, okay? None of those tax dollars, go to us. I mean, yes, they pay our salaries. We work for the citizens of Pinellas County, okay? That's what we're here for. Right. Right. Right.
Paid off, completely paid off.
Oh, yeah. Yeah.
Whole, soon after we went back into the process that you're talking about, no longer this and ownership change. We went from the valley to the mountain, just
Yep.
like that.
Yes, ma'am. Yes, ma'am.
Almost $9,000 in taxes. I had to go from one to the other. It was ridiculous.
Okay, portability. Okay. What you do is if you sell a home in 2023, you bought a home in 2023. Let's say they're both in Pinellas County. 1/1/24, that new home gets valued to market value, right? That value that we place on it compared to the value, the market value of the home you sold in 23, January 1, determines the amount of portability that you're going to get. If the new one is more than the old one, you get that full differential you had in your old one. If it's less, it's prorated. Okay, that's called a downsize, subject to a $500,000 cap. You can't get more than $500,000 of portability. Now, you say that sounds like a lot of money. You would be surprised how many homes in Pinellas County have more than $500,000 of assessment differential, especially in the last 4 or 5 years. Okay, so just value of new, the January 1 after you bought it, compared to just value of old, the January 1 in the year you sold it, times that differential that you had on the old, that determines the portability. Now, again, one thing that Mr. Twitty did for the taxpayers of the entire state of Florida. In the past, you had 2 January 1s in order to transfer your portability. So if you sold January of 1 year, you almost had a full 2 years. Okay, January 1 of the year you sold, January 1 of the next year, you can port to January 1 of that 3rd year. What was happening? People would sell in December. They have 13 months to qualify for homestead on a condo that they put a contract on pre-construction price. Condo didn't get done. By the next, in 13 months, it was delayed. They couldn't move in until February. They lost their portability, every bit of it. Mr. Twitty got a amendment on the ballot that the voters voted for. He pushed it through to add a 3rd year. So it truly is 2 full years, even if you sell in December. So there's 3 January 1s. January 1 the year you sell, January 1 the next year, January 1 the year after that. By the end of, before that 4th January 1 comes around, you have to homestead another property in order to get your portability. Okay, and there also is a concept, by the way, if you for whatever reason, we do our best. When people apply for homestead, they always give us their previous address. If they forgot to apply for portability, which sometimes they do, although our website asks them, do you want to apply for portability? We pursue them, but if we miss it, you can also look. I'm the prime example. My wife's in real estate. I blamed it all on her. Okay, we moved. We had port. Never applied for portability. Never. We went 2012, 13, 14, 15, 16. I joined the property appraiser's office. And I said, is there a concept of delayed portability? Yes, there is. There is a concept of delayed portability. I could take my differential from 2012 and move it forward to 2017. You don't get the benefit of all those years in between, but so if you forgot and you think you're entitled to port and you homesteaded within that 2-year period, if it was before 2019 or 2020, or the 3-year period now, you can move that differential, but you have to apply. Everything in our world you have to apply for. Yes, ma'am. Yes. Yes, ma'am. If you created a differential, when did you buy the new home? And you sold the one? Perfect. You hopefully, and you can, right after our meeting, please go to the front desk up front. Hopefully we have already applied your portability to your new home. But if we haven't, you apply for it, we'll make sure. Okay? All right. Again, if you don't think you ever applied for portability, please contact our office. Recent legislation. The Florida legislature keeps us in business because they like to make changes every year. Sometimes not drastic or dramatic, but portability was a big one, right? And also in 2019, I believe, the 10% cap had a 10-year window on it where it was going to go away. And all 10% property were going to go to market. That came on the ballot. And the voters, with 60% of the vote now, it's 60% of the voters, extended it in perpetuity. That would have been a very bad issue if all the 10% cap properties just went to market because the voters decided they didn't want it to, but it was a good decision. So just quickly, not any of this is not etched in stone at the moment. You check my time. How am I doing? Okay, we're doing okay. This is very important. Again, this is championed by Mr. Twitty. Okay, when Mr. Twitty first came into office, he put a tax estimator on our website that estimates the taxes that you're going to pay the year after you purchase, which means you go to market, which includes portability. The estimator includes portability if you had a prior property. Unfortunately, you go online today and you look at Zillow and other, they display the taxes that exist on the current home. Go back to my example, that's $777, right? It's, oh, taxes are only $777, listed at $450,000. This legislation will require anybody who has a listing, MLS, anybody who has a listing online to either have a link to an estimator or actually estimate the proper amount of taxes the year after purchase. This is really a consumer protection law that everybody should be aware of. Again, it's all over our website. We do the best we can, but I have personally heard from realtors who are do the right thing and tell their clients your taxes are going to go way up, just so you know. And there are others that say you should buy this house. The taxes are really low. So this is an important piece of legislation that I believe will, we're really hoping this passes. And again, Mike Twitty, along with Senator Hooper and the House Anderson, bought into this and say, yes, it makes sense. Everybody should know this, because sometimes mortgage companies don't take it into account. Okay, that increase in taxes. Yes, sir. The argument against it could be nobody's going to buy this house if the taxes are going to be too high. Not at that price. That's the only argument I can think of. But oh, they do. And guess what? You're not going to deal with that realtor ever again, are you? Because they didn't tell you anything.
What can we do? When is the legislation session going to take place? And what can we do to help? That's not.
Well, I mean, you could contact your senator and representative who are sponsoring this bill and say, look, this makes too much sense. We want this to pass. And this doesn't require a vote of this could become law. This doesn't have to go to the voters, because it really doesn't affect taxes. Anything that affects increase or decrease in taxes has to go to the voters. This does not have to. Okay, there are other things here. Verification of eligibility for homestead. This primarily for total and permanent. There is a potential bill that would allow them to contact our office to see if they would qualify before they buy, as opposed for the total and permanent. This is a little tricky because the timing of all this is important, and mortgage companies want to know what the taxes are going to be, et cetera, et cetera. But there's all other issues that, besides just being total and permanent, they got to be, they have to be Florida residents. They have to all this stuff. So again, a good bill. Limitation on property tax assessments, to improve the exception for school district levies. I don't know that's going to have any legs. Reduction of assessed value. Granny flats. Granny flats are kind of an interesting thing. It's not approved in Pinellas County. Some counties have it. It's a county option, where if you have a separate structure on your property that mom and dad or mom and dad-in-law live in, and they're over a certain age and they don't have homestead somewhere else, you can get a reduction in your assessed value up to 20%. For them living there. Annual adjustment of homestead. Homestead's been at $50,000 since 2008, right? Well, prices have gone up. They're looking at a CPI increase to the homestead exemption to have it ride along with CPI. Tax exemption for disabled service members. There's a proposed amendment, but I believe that would have to go to the taxpayers to go from 5,000 to 10,000 exemption. Discount for disabled veterans. Again, this is only disabled veterans that were wounded in combat qualify if they're over 65. This would then open it up to anybody who's been awarded the Purple Heart. And then surviving spouse of quadriplegics, just to make it equal with surviving spouse of TNP. And then tangible personal property. People who own a business, a restaurant, for instance, they pay tax on all their equipment. Okay, there's a proposal to increase the exemption from 25 to 50,000 for TPP. Right now, it's at 25,000. Real quickly, I've got 1 minute. Common missteps. New home buyers rely on the taxes. I think we beat that to death today. Homeowner transferring their homestead cap to an LLC triggers a reset. Cap resets when, again, 10% cap applies for homestead, triggers a reset. Don't rent your property if you have homestead. If you do, we'll find out. And you don't want to be hit with a 50% penalty and 15% interest. On the unpaid tax, plus the unpaid taxes. Changes to the deed. If you're unsure whether it will affect your homestead, contact our office, please, before you file it, because once it passes January 1, and a lot of people do this as a tax planning or estate planning measure in the month of December. And they file a deed December 28th. We don't see it till after January 1. We can't help you. The die has been cast. You add a son or daughter on it and you forget about tenancy. You just have it from you to you and your daughter. Don't say joint tenants with rider survivorship. Don't say anything. Guess what? You now own 50% each and you lost 50% of your homestead. So it's important. Real quickly, all kinds of information on our website. Please visit our website, www.pcpao.gov. We have not only the tax estimator, but tips and buying a home and selling a home and what you should be aware of with regard to your property taxes and your values. Tax estimator, there it is. It's really a useful tool. Please use it. Because it will, you just put in the house you want to buy, the house you're sold with your portability, and it'll print out what your taxes will be the year after purchase. Property fraud alert service. I recommend everybody sign up for this. It's a free service offered by the clerk of the court. Go on their website. Anything that is filed in your name at the clerk of the court or anything close to your name, you can get an alert that we either by text, by email, your choice. But there's all kinds of things that are satisfaction to mortgages are filed in your name. There has been quite a bit of deed fraud throughout the state of Florida, where somebody goes into a nursing home and somehow somebody finds out about it and they try to deed the property over to somebody. And there have been many arrests in Pinellas County. There are thieves out there who try this, but anytime it's filed, you can react right away. Follow us in the know, all kinds of Facebook, YouTube, sign up for our newsletter. And when is the next session, Kyle? It's in March. It's usually okay. And that is property tax for business or? Okay, that's for tangible personal property taxes. Please join us online or in person. We'd love to have you. And questions? Any questions at the last minute? Yeah, you can. There'll be a link to the presentation itself on the website. And is it the video? It's a full video, right? Yeah, yeah, yeah. Well, once again, all thank you for your attendance. We really appreciate it. Thank you for joining us. We're happy to educate you about the nuances of property tax, and have a great day.